about playing professional hockey for the Detroit Red Wings. That never happened. About being engaged to a Mexican starlet. Never happened. Of having freed the American ambassador to Iran during the Iran hostage crisis. Never happened. And then somehow he was elected to this little water board down in Southern California. And he introduced himself at the first meeting of that he had attended of the water board, saying, "I'm a retired Marine of 25 years. I retired in 2001. Back in 1987, I was awarded the Congressional Medal of Honor. I got wounded many times by the same guy. I'm still around." And the only true part of that was I'm still around, because he never served in the Marines, he was never wounded, and he certainly never got the Medal of Honor, which is it's the Congressional Medal of Honor. It's one of the greatest honors that can be bestowed on anybody in the military. So he was exposed fairly early on by the local folks in the local press, who exposed him as a phony and a liar, treated him as the ultimate slime, one of the articles about him said. And somebody gave the FBI tape of his introduction that he had given at this meeting, and the FBI turned it over to the U.S. Attorney in Los Angeles, who then prosecuted Alvarez for the felony of having lied about receiving the Medal of Honor. The statute, which was just enacted in 2006, through all of our history, we've had military medals starting with the Revolutionary War, but never was there a legal protection or a legal prohibition on falsely representing that you received a medal until 2006. Whoever falsely represents himself or herself, verbally or in writing, to have been awarded a medal is guilty of this crime, and if you falsely say that you got the Medal of Honor, that qualifies for an enhanced sentence up to a year in prison. That's the law that Alvarez was prosecuted under. The Congress, in enacting the law, as Congress frequently does, makes findings to sort of give some context to the law that they're passing. And the Congress found that fraudulent claims about getting medals damage the reputation and the meaning of the medals, and so on. And so legislative action is necessary to protect the reputation and meaning of military medals. That's the statutory purpose. That's the government's expression of its interest in making criminal the speech, pure speech, of lying about receiving a medal. Well, Alvarez pleaded guilty. He didn't have much of a defense. He knew that he hadn't received, he wasn't mistaken about whether he received the Medal of Honor. He pleaded guilty, but it was on condition that he could appeal on the issue of whether the law was consistent with the First Amendment. So he did appeal, went to the Ninth Circuit Court of Appeals, which, when they initially heard it, split 2-1, with the majority holding that the statute was unconstitutional, was a violation on its face of the First Amendment. Not just as applied to Alvarez, but that the law couldn't be enforced against anybody because it was a violation of the First Amendment. And the government then sought rehearing by the Ninth Circuit Court of Appeals en banc, that is the full court, and the case was then decided. Well, it wasn't decided. The full court decided not to rehear the case by a vote of 8-7, 15 judges voting, and the majority, 8, deciding that the case should not be reheard. And what I included in the reader are excerpts from the opinions on the question of whether the panel decision, the 3-judge decision, should be reheard by the full court. And the court decided not to rehear it. The reasoning of the majority in holding the statute unconstitutional has some steps. That is, one is that this is speech, this is pure speech, and the presumption under our First Amendment is that all speech is protected, unless the government shows that a certain category of speech has historically been unprotected, or there's a compelling need to prohibit the speech for some reason other than it's simply a lie. And the court looked to the Supreme Court's decision in the Stevens case that we've considered, that's the animal cruelty case, where the Supreme Court refused to create a new category of unprotected speech. And the Stevens categories mentioned by the court as historically being unprotected, the court listed obscenity, defamation, libel, fraud, incitement, we'll reach that when we get to the Brandenburg case, incitement to imminent lawless action, and speech integral to criminal conduct, proposing the commission of a crime, for example. Those are categories that the court listed in Stevens as not historically protected. I think that didn't purport to be an exhaustive list of those categories. For example, perjury, they could have said, is an unprotected category of speech, lying under oath. False advertising may be considered a category of unprotected speech, at least if it misleads someone. And the Ninth Circuit said that simply falsehood, simply lying, is not and has never been in a category of unprotected speech. The court had to deal with a statement in the Gertz case, Gertz versus Welch, where the court said that the erroneous statement of fact is not worthy of constitutional protection. But the Ninth Circuit said that statement doesn't mean that false statements are never protected, because look at Sullivan, look at Gertz, where false statements were protected, at least to the extent of the need to give breathing space to true speech, so that you don't have a chilling effect on true speech, or speech that matters, as the court said in the Gertz case. Well then, the Ninth Circuit says if simply falsehood is not in a category, is not unprotected because it's false, this law the Stolen Valor Act is a content-based restriction on speech, singling out the statement that I won the Medal of Honor for criminal prohibition. And since it's content-based, then under conventional First Amendment analysis, strict scrutiny applies, and the government must show that the restriction is intended to serve a compelling government interest and is narrowly tailored to serve that interest. And the bulk of the discussion in the Court of Appeals was whether that was true. The majority in the Court of Appeals sort of casually assumed that the government's interest in protecting the reputation, meaning, integrity of the medal program was a compelling government interest, and then focused mostly on whether the law was narrowly tailored to serve that interest, and found that it wasn't narrowly tailored, that there were other means of protecting the government's interest, less restrictive than criminalizing the lie, namely the remedy of more speech. That is, the remedy for speech that you disfavor is not suppression, but allowing more speech. And in the case of somebody like a phony medal winner like Alvarez, more speech means exposure in the public, and that deals with the problem as effectively as criminal prosecution. In the Ninth Circuit, the lead dissenter was on the rehearing issue was Judge Darmond O'Scanlan, who was my law school classmate, was a nice Republican boy from Oregon, and became head of the Republican Party in Oregon, and then was put on the federal bench. I think it was President Reagan appointed him some years ago, and he's one of the leading conservatives on the Ninth Circuit. And he was, you see his opinion, he was highly upset by the court's treatment of the statute. And his view was that, as a general rule, false statements of fact are unprotected by the First Amendment. It flips the proposition that the majority embraced, which was that all speech is free unless it's in a category of unprotected speech. And rather, O'Scanlan's proposition was false speech is unprotected, categorically, unless it's necessary to permit the expression of true speech, speech that matters. And he takes issue with the majority view that all speech is protected under the amendment. Under the amendment, he says what is protected is the freedom of speech. Congress shall not abridge the freedom of speech. Doesn't say all speech, doesn't say speech, it says the freedom of speech, and that requires, as going back to the beginning of our course, that requires a court to decide what's included within the freedom of speech, and O'Scanlan says falsehood isn't included. Because false statements are categorically unprotected, he says there's no basis for engaging in strict scrutiny. And of course, if he's right, that's right, that the court shouldn't have applied strict scrutiny. It should simply have upheld the conviction of Alvarez on the ground that the statute only prohibits speech that is not protected by the First Amendment at all. Judge Alex Kosinski, I warned you about him before, he's the most entertaining writer of all the judges in the country, agreed that what the Congress had done was a violation of the First Amendment, and said we all lie all the time. And without the protection of the First Amendment, the white lies, the exaggerations, the deceptions that are an integral part of human intercourse would become targets of censorship. Truth is not the sine qua non of First Amendment protection. We know that from Sullivan, right? No test of truth, at least with regard to political speech. Query whether what someone like Alvarez is doing is political speech. And he says that this conviction is especially troubling because Alvarez was being punished for speaking about himself. Not about somebody else, but about himself. And that infringes an important First Amendment purpose, human self-expression. Not only do we need free speech to facilitate democracy, to get to the truth in the marketplace of ideas, but the ability to express ourselves, to have our own autonomy in what we say about the world and about ourselves, is a vital part of what's protected by the First Amendment. And he quotes Justice Thurgood Marshall, that the First Amendment serves not only the needs of the polity, but also those of the human spirit, a spirit that demands self-expression. That's an integral part of the development of ideas and a sense of identity. To suppress expression is to reject the basic human desire for recognition and affront the individual's self-worth and dignity. I'm happy to say that Justice Marshall said that in the Martinez case, Procunier versus Martinez, the case that we considered in connection with Danny Martin, involving the rules of the California prison system. And speaking about oneself, Kosinski says, is precisely when people are most likely to exaggerate, obfuscate, embellish, omit key facts, or tell tall tales. Saints may always tell the truth, but for mortals, living means lying. Americans tell somewhere between 2 and 50 lies each day. Anybody here who's never lied? Oh, Kelly. That's a lie. Some studies, so between 2 and 50 lies a day. So Kosinski thinks it would be terrible to uphold this law, and that we would have the government acting as the truth police and going after people. That's a slippery slope argument that he makes. If you uphold this law, where lying about a medal is prohibited, what's to prevent the government from outlawing all kinds of other lies? Like, for example, that you served in the military. Lots of people lie about that. Lots of politicians lie about that. Lots of politicians lie about their qualifications, grossly exaggerate to the point of falsehood about their own qualifications and about the qualifications of the people who are running against him. And who knows where the line can be drawn to stop that. In the argument last week in the Supreme Court, Justice Kennedy asked the government lawyer, well, a high school diploma is an important thing in American life, and doesn't the government have a valid interest in making sure that people have high school diplomas. So a lie about whether you graduated from high school could be outlawed. And it's hard to know where to draw the line and stop all this. In the argument last week, the transcript I put on BSpace, the government lawyer, the Solicitor General of the United States, Donald Verrilli, remember the Solicitor General is the government's lawyer in the Supreme Court. First thing he says, almost first thing, is that this law regulates a carefully limited and narrowly drawn category of calculated factual falsehoods. It advances a legitimate, substantial, indeed compelling governmental interest, and it chills no protected speech. And later on, he elaborates that with respect to the government's interest and why there's harm to that interest, says this is a big deal for the government. You get a medal for doing something very important after a lot of scrutiny, or whether you deserve this honor. And for the government to say this is a really big deal and then to stand idly by when one charlatan after another makes a false claim to have won the medal does debase the value of the medal in the eyes of the soldiers. It does do that. That's the government's interest. We think it is a real and substantial interest, and it's threatened here. And then Verrilli argued first, then the lawyer for Alvarez argued second, defending the Ninth Circuit decision and the outcome. There, the lawyer for Alvarez is a Jonathan Libby, who's a deputy federal public defender in Los Angeles. And during his argument, Chief Justice Roberts says, what is the First Amendment value in a lie, pure lie? Somebody have a good answer to that question? What's the value of a pure lie? Catherine? Yeah. It enhances the search for truth, because when truth collides with error, with falsity, that makes the truth clearer. John Stuart Mill's, Libby didn't say anything about Mill answering that question. He then got a question soon thereafter from Justice Kagan, who has, as a scholar at the Harvard Law School, wrote extensively about the First Amendment. And she asked Libby, what truthful speech will this statute chill? Has a chilling effect? What truthful speech does it chill? You have an answer for that one too, Catherine? No. You don't want to say none, do you? That's not going to win the case, Sam.
Maybe speech is true, but you can't verify it if there's a conflict of records or something?
Yeah, sort of the idea that speakers will steer clear of the prohibited zone and won't say true speech for fear of being prosecuted. But gee, in this medal context, pretty clear to the speaker and pretty easily verified whether the speaker won the medal or not. So what truthful speech does this law chill? Robert?
I have a hard time with this law because there's so few medal honors that there's so few medal honors that you have to do so much to get it that it doesn't, to me, it doesn't diminish the award at all. There's some level I have to say that God is I know that you're for it, so why does that diminish the award? That's the problem that I have.
If you look at the government's brief in the case, which you may do if you wish, it's pretty heavy going, but I put them on BSpace. If you look at the government's brief, they say that, well, maybe an isolated instance of lying about a medal, one Alvarez, is not a big deal. But in the aggregate, the government's saying, to free people to lie about the medals, that a lot of liars out there surely debases the meaning and reputation of the medal. Do you let them get away with it?
I remember one scenario that was brought up that if you outlaw lying about a medal, you might show the ability of someone to use that as a motivating tool, like a grandfather telling his grandson, oh, when I served, I won the medal of honor, and all this to kind of motivate the grandson. Also, it could show valuable lives. I think the example he gave was if the government, if in a World War II context in Germany, for example, the government asked you if your children too, you said no, it's not the type of lie that should be helped. It kind of goes back to also the physical argument, but it's kind of trying to make for a lie possibly being speech that matters.
Yeah, of course, the statement there, no Jews hiding in the basement, is pretty far afield from claiming that, shame on you. The penalty for that is confiscation. No, just don't. Well, that was a distraction. That's why cell phones are prohibited in this, not just speech on cell phones, but having one within sight is prohibited in this classroom. Jews in the basement is pretty far down the slippery slope from this. That's what Robert said in Stevens. The question is he going to say something like that here? Most of what